All right, I'm going to get us started. Thank you all for joining us. My name is Carol Levine, and I have the honor of chairing Courts Matter Illinois. And I want to welcome you to our final webinar in our series, Courts Matter in the 2020 election. This one is Courts Matter to Reproductive Rights. A few housekeeping items before we get started. First, this webinar is being recorded. It will be available in a few days on our YouTube channel. So if you miss anything or if you want others to know how they can find it and listen to it, if that's where you'll find it, and you can check on our Facebook page to find out more about that. All of your microphones and your cameras are turned off so that only the speakers, cameras, and microphones are on. Please put any questions you may have in the Q&A box that's at the bottom of your screen, and any comments that you have in the chat box. We'll keep monitoring those throughout the webinar, and try and get back to you at the end of the webinar with the questions, and we'll try and get to chat comments as we can throughout the webinar. Before we begin, I have a few thank yous to some organizations that have been sponsoring these webinars throughout the series. So a big thank you to the following organizations: Chicago Women Take Action, National Council of Jewish Women, Chicago North Shore Section and South Cook Section, National Council of Jewish Women's State Policy Committee, Planned Parenthood of Illinois, the American Constitution Society Illinois Chapter, National Employment Lawyers Association Illinois Chapter, and the Citizen Advocacy Center. I'd like to tell you just a little bit about Courts Matter Illinois before we get started. Courts Matter Illinois is a coalition of diverse organizations and individuals working to ensure a federal judiciary that's comprised of judges who are committed to upholding core constitutional values. Core constitutional values include such things as voting and civil rights, workers' rights, freedom of speech, the separation of church and state, and the right to privacy, among many others. Here's a few of the things that we do. We educate the public and our elected officials about the importance of federal judges who sit on the U.S. District, Circuit, and the Supreme Court. We provide information to the community about the judicial nominations process and judicial nominees who will impact our constitutional rights and other fundamental rights. We support a judicial nominations process that is fair and identifies well-qualified, diverse, and unbiased nonpartisan nominees. We mobilize communities to speak out and take action on federal judicial vacancies at all levels of the federal judiciary, including the Supreme Court. Courts Matter Illinois monitors and takes action to ensure fair consideration of federal judicial nominations because of the immense power held by the individuals who hold lifetime seats on the federal bench. Having said that, in all of our other webinars, we have done a very short PowerPoint on the federal judicial process, taking less than 5 minutes. Today, we're making a change. Because of what's going on right now in Washington, D.C., today we're going to do an even shorter PowerPoint on the federal process of nominating Supreme Court justices. So Mike, who is behind the scenes making everything happen, is now going to manage the slides for me, something I could never do. And so the Supreme Court process then and now. Okay, here we go. First slide, Mike. Go ahead. Next slide. The first step, the president selects his, or maybe someday her, candidate for the court. Often, this selection process takes some time, but right now, it took almost no time. With the vacancy on the court, this time precipitated by the death of Ruth Bader Ginsburg, it took very little time for the president to announce his selected candidate for the vacancy. Once announced, the candidate's background is usually vetted by the FBI, and that report is shared with the Senate Judiciary Committee. That vetting usually takes weeks, if not often a month or more, to do. I'm not even sure that that vetting happened with this candidate, although they're saying it happened 3 years ago when she was vetted for her position on the appellate court in the Seventh Circuit. Also, the writings and documents of the candidate are compiled to be shared with members of the Senate Judiciary. Again, this compilation process takes an enormous amount of time. That time did not happen with this present candidate. Next slide. Following the announcement of the nominee and those other steps I just talked about, the nominee will answer an elaborate questionnaire which is examined by the Senate. This questionnaire is often hundreds of pages long. I am not aware of how or when that questionnaire was filled out by this candidate. Then, the candidate begins private meetings with the senators. These meetings are closed-door meetings, often lasting between 15 minutes and an hour, and can take weeks or months to complete. In many cases, this candidate is escorted around the Hill from Senate office to Senate office by sort of an entourage of one senator who is sort of her guy or his guy, and they go from place to place. Since many senators are not even on the Hill right now, and many senators in this case have opted not to meet with the candidate or to meet with the candidate by phone, this has been a very unusual time, and many meetings have not taken place. Then the nomination goes to the Judiciary Committee, where the process may vary depending on which party is in charge and who sets the rules. And as you know, yesterday those hearings began, and they are going on as we are here today. Next slide. A televised hearing will be conducted by the 22 members of the Judiciary Committee. How much time each senator has for questions and how long the hearings will last is up to the party in charge and the process they set. The questions asked will vary, but nominees will not take position. Nominees for the Supreme Court will not take positions on issues that might come up before the Supreme Court. And anyone who has listened this morning to Amy Coney Barrett, who is the nominee, will have heard her say over and over again, I'm sorry, Senator, but I cannot answer that question because that is a case that may come up before the court. Even questions about, has that case been rightly decided? If it's a possibility that a case may be overturned, she will not take a position. After the hearings, the Judiciary Committee will vote and send the nomination to the full Senate. Next slide. It's not known how much time will be allotted for floor debate in the full Senate on the Supreme Court nominee. A number of traditional processes that allowed for debate on judicial candidates in the Senate floor which used to be up to 30 hours, or even a filibuster on the nominee, were set aside at the end of the Obama administration. The majority leader can now call for a vote with limited time for debate, 2 hours, on the floor of the Senate. It takes only a simple majority to confirm a judge for a lifetime position. And with one party holding the majority of the seats in the Senate, the votes on these nominees are most often along party lines. In the case of a tie vote, the vice president will cast the decisive vote. As we know, there is a majority party. It would take at least 4 Republican senators to vote no on Amy Coney Barrett for her not to receive this seat on the Supreme Court. So it is highly likely that she will become the next Supreme Court justice, and that it is highly likely that this nominee will pass the Judiciary Committee before the election, and that a vote will be called before the election, and that she will be seated before November 3rd on the Supreme Court. So that's sort of the process. I have 2 more slides that I would like to show you. So let's go to the next one. There was a story told about Ruth Bader Ginsburg, who was once asked, was there a right number of women to have on the Supreme Court? When would there be the right number? And her answer to that was, when there are 9. I've thought about that a lot lately. And my thought was that perhaps today she might respond, when there are the right 9. So I just put that up there as something to think about. Next slide. This is sort of a what you can do slide. First of all, we ask that you pay attention. Secondly, raise awareness. Use social media, submit op-eds and letters to the editor about the courts. Call your senators and urge them to reject extreme and unqualified nominees, whether it's to the Supreme Court, to the district courts, or to the appellate courts. Ask your networks, especially those in other states, because in Illinois, we live in a state where, for the most part, our senators are pretty good on judicial nominations. Educate others on the importance of the courts. Connect it to everything you do. And of course, vote. So, thank you, Mike. That's the end of our slideshow. Now, it is my great pleasure to introduce the moderator of our webinar, Dana Pownell, who's a nonprofit institutional advancement professional at Chicago-Kent College of Law. Her commitment to progressive issues began when she was an undergraduate at Washington University in St. Louis and chaired the committee organized for rape education. Her first job after graduating was as a volunteer coordinator for Legal Advocates for Abused Women. After a career in corporate training, sales, and marketing, she went to law school, where she was a founding member of her law school's chapter of Law Students for Reproductive Justice, now known as If, When, How, Lawyering for Reproductive Justice, as well as president of her law school's chapter of the American Constitution Society. In her spare time, Dana helps to organize events like this one as a director of programming for the American Constitution Society Chicago Lawyers Chapter, a member of Courts Matter Illinois Steering Committee, which we are very grateful for, and a member of Reform for Illinois' Board of Directors. So I'm now very glad to turn this over to Dana and our wonderful panel of experts to talk about why courts matter to reproductive rights. Thank you.
Thank you so much, Carol, and thank you to everybody who's joining us for this webinar. We have 4 great panelists who are going to talk at length about why courts matter to reproductive justice and why reproductive justice is so important. Hopefully you won't be hearing very much from me moving forward. And with that said, I'd like to introduce you to our panelists. We have Aisha Chaudri, who has been a social justice activist for over 21 years and has been working in reproductive justice for over 13 years. Currently, Aisha is leading the Contraceptive Justice Project at Everthrive Illinois, the co-chair of the board of directors at the Illinois Caucus for Adolescent Health, and is a steering committee member of the American Society for Emergency Contraception. Aisha's commitment to anti-oppression work stays rooted in the experiences of marginalized communities, including Aisha's own queer, femme, Punjabi, immigrant, and Muslim identities. Andy Friedman is a lawyer and advocate with extensive experience working in reproductive rights and health. She is the president of AF Advocacy and currently works on abortion access throughout the country, as well as serves on the boards of Personal PAC and the Midwest Access Project. Her previous experience includes serving as the Director of Reproductive Health at the National Partnership for Women and Families, Foreign Policy and Defense Legislative Aid to the late Senator Frank Lautenberg, Democrat of New Jersey, and founding Vice President of the Global Justice Center. She has a JD from Harvard Law School and a BA summa cum laude from Tufts University. Jennifer Welch is the President and CEO of Planned Parenthood of Illinois. PPIL operates 17 health centers, which served more than 66,000 patients last year. Before coming to PPIL, Jennifer was first Deputy Commissioner of the Chicago Department of Family and Support Services. She previously served as Policy Director for Illinois Attorney General Lisa Madigan. Before her tenure in government, Jennifer was the Executive Director of the Chicago Metropolitan Battered Women's Network, which is the coalition of Chicagoland's domestic violence service providers. Ms. Welch holds a JD from Chicago-Kent College of Law and an undergraduate degree from the University of Illinois at Chicago. Last but not least, Emily Werth, she/her, is a staff attorney at the American Civil Liberties Union of Illinois, where her work focuses on women's reproductive rights. Emily joined the ACLU of Illinois in the fall of 2014. She is a 2006 graduate of the University of Chicago and a 2011 graduate of Harvard Law School, where she was active in the Tenant Advocacy Project and the Employment Civil Rights Clinic, and was an editor of the Civil Rights, Civil Liberties Law Review. Before coming to the ACLU of Illinois, Emily worked as a Skadden Fellow at the Sargent Shriver National Center on Poverty Law in Chicago, and then as a fellow at the National Women's Law Center in Washington, D.C. Ladies, thank you all so much for joining us today. And without further ado, we're going to jump right in and discuss why are reproductive rights important, in case anybody had any questions about that. Andy, would you like to start off talking about some of the major cases? I think you're still on mute. I'm sorry.
Thank you. So, I think it's such a pleasure to be here. And what an interesting and complex time to be having this discussion for sure. Jumping in on the sort of the top level of, why do courts matter? It's a challenging moment, as I was saying, as someone who went to law school to do abortion advocacy, thinking that I needed a better handle on the law to get there. There's been almost something of a disillusionment process over the past decade or two, because I think what's really becoming clear with this nomination is that courts matter because they have become a reflection of who has power, right? And so political power, but also cultural power and how power gets built. And many would argue that around abortion access in particular, the idea that courts are going to save us has actually undermined some of our efforts to point out that the reality of Roe v. Wade, which we'll be talking about more, I'm sure, the reality of it is far different than what the vision of it was. And it has really become a floor for access, and one that is full of cracks. And that if you are someone who faces structural economic barriers already, which generally means if you're going to be Black, a person of color, a person stuck in cycles of poverty, that you already don't have access or have lost access. And I know we're also going to talk about that a lot more in the next hour, about what access actually really looks like. So I think if we're going to see progress on issues like reproductive health, rights, and justice that we care about, we need to be building power broadly in all areas, knowing that these are all levers around how we or others are going to advance their agendas. And the Republicans and those who want to take away our right to access and control our reproductive health have understood this for decades and been working on it for decades. And now we're seeing the outcome of that, unfortunately. And we can see President Trump making a very concerted effort to fill these slots. Mitch McConnell has not hidden the fact that as soon as he had power in the Senate, he stopped President Obama from getting through his nominations. A report just came out from the Center for American Progress noting, just looking down here, that they confirmed the McConnell-led Senate Judiciary, it confirmed the fewest judges in more than half a century, including only 2 appellate court judges. All told, McConnell's conservative Senate allies held open more than 110 judicial seats by the end of the Obama presidency. They made it a priority to make sure that those spots were held open, and they used that. They then held open a Supreme Court spot, which will forever go down as infamy, as using that to then win the election for Donald Trump, and he has now been pushing through his nominations. Marjorie Dansfelder, who is a leader in the anti-choice movement, she runs an organization called Susan B. Anthony's List, a very, very powerful political organization, has direct access to the White House, and has said that President Trump will only appoint judges that she gives to him. So it is a political process at this point. And we have to recognize that, and we have to start building power to counter that. So I realize that was a little off of your question, but I thought that was an important overview before we dig into the actual cases at hand and where all the chipping away has been happening over decades and is how it's going to get worse, because I think it's really important to understand that while we'd love to think of the courts as harbingers of truth and justice, right now I think it's important to recognize that they are also just a critical tool for wielding power. And right now, in an undemocratic way, the Senate doesn't need to have the votes in the Senate and the House to get rid of the Affordable Care Act or take away our access to abortion, because they can do an end run around the legislative process by putting in the judges they want, and now the justices they want.
And that, ladies and gentlemen, is why the courts matter to reproductive justice. Aisha, do you want to say a few words about how access to reproductive justice disproportionately impacts under-resourced communities?
Sure, thank you. I wanted to also clarify that reproductive justice is achieved with reproductive health care, reproductive health education, and reproductive rights, defending those rights, right? And so getting to the point of justice requires us to have the rights in place to begin with. So like we're wanting to ensure that folks have these rights, but they're basically at the core of like bodily autonomy and also creating the families that we want to have and being able to live and thrive with them. And that is how reproductive justice also names that when we're talking about repro rights, it's not just about the right to have contraception and not carry a pregnancy to term. It's also the right to have families that we want in the ways that we want. We know that Amy Coney Barrett is also against IVF. Right, she wants to criminalize people if there are discarded embryos in the process of IVF. And that inherently is a way that people create families, right? Folks who don't have reproductive capacity themselves. So this is a direct attack on also families. Pro-choice is pro-family, right? Majority of people who are parents are the ones who are seeking abortion care. So just wanted to name that reason the reproductive rights is so important to not just people who have uteruses, but to everybody. It's about our actual families and how we can survive and thrive and create the families that we want to have and live the life that we want to have as well. So it is a core human rights value. It's actually deeper than just repro rights. It is a human rights framework. And we have, assumed that our rights would be protected because we've assumed that there's a base level of understanding around human rights and civil rights, but we have not achieved that just yet, which is why it's being shaken so much. And so how this trickles down to communities is that this language around legal rights doesn't always translate to how people talk about their own day-to-day access, right? And so when we see changes at the federal level, it creates panic, it creates fear, it creates confusion. And for folks who, as an immigrant myself and whose primary language wasn't English for a majority of my life, like understanding legalese into the way I was going to navigate my care, there's a filter that goes through that, right? And so there are folks who feel like there is no care, that the care has already been taken away right now. So there's just a lot of barriers, misinformation, confusion about what even reproductive rights includes and who it impacts. It's viewed as maybe sometimes a fringe conversation of it only impacts certain people, and it's actually not true at all. And that as we take away human rights of people, like this is a longer term strategy to keep folks away from being able to live the lives that they want to live. And what we've also seen with the executive order to denounce anti-racist training and anti-sexism training, right? This is also a strategy to deny people the right to live the life that they want to live. And so we'll definitely get into more specific examples later on, but the main point is that people are being denied what they have rights to, or being told that they don't have those rights, even though they might be already in place.
Thank you so much, Aisha. So we've made reference to Roe a few times already. Emily, I know there are some holes in the rights that Roe bestows upon us, regardless of whether or not it stands through Amy Barrett-Coney's appointment. Would you like to speak a little bit more about local litigation and the issues that you face?
Sure. So I actually think I'll take it back a little bit farther than what's going on right this second, because what I think maybe not everyone is aware of is that the holes in Roe have existed almost since Roe happened. So the Supreme Court decided the Roe case in 1973, and it found a right in the U.S. Constitution that applied, nationwide for a person to have an abortion and terminate their pregnancy. But almost immediately, both state legislatures, including the Illinois legislature, which was quite anti-choice at the time, and the federal government started adopting various measures to try to chip away at that right. And many of those measures were challenged up to the Supreme Court, and the Supreme Court let many of them stand. So an issue that's very close to my heart, because it's something that I've worked on considerably here in Illinois, is the issue of young people's access to abortion care, and whether the state can mandate that young people must involve their parents or other family members before they have an abortion. The Supreme Court decided in 1979 in a case called Bellotti versus Baird that those mandated parental involvement laws are in fact constitutional, and that even though young people do have a right to abortion, it's not the same as the right that an adult person has, and that the state can mandate that either young person involve their parents, or in the alternative, go to court in a process that we know is judicial bypass and basically seek permission from a judge to have an abortion without family involvement, which, as you can imagine, is a very intimidating, challenging process for many young people to navigate. And so that was, over, 40 years ago, one of the first instances of the Supreme Court saying, sure, we have this right to abortion, but it isn't equally available to all people when it comes to actual access to care. The next year, in 1980, there was a case called Harris versus McCrae, the Supreme Court decided, which basically upheld the validity of the Hyde Amendment, which, for folks who don't know, is a federal appropriations rider that has been attached to pretty much all federal spending bills since the 1970s, which says that federal funds through Medicaid, but also a lot of other types of programs, Indian Health Services, military spending, et cetera, cannot be used to pay for abortion care. So in Harris versus McCrae, it was particularly challenging this with regard to people who received their health insurance through Medicaid. And the court held that there was no constitutional problem with the Hyde Amendment, and that just because someone has a constitutional right to have an abortion does not mean that they have a constitutional right to have the government, let me choose my words carefully. They don't have a constitutional entitlement to the financial resources to avail themselves of the whole range of their pregnancy choices. So basically, the government is free to put a thumb on the scale in favor of continuing pregnancy by paying for that, but denying someone coverage for an abortion if that would be what they chose. And so again, for 40 years, that has been the law at the federal level and in many states, that if you have your insurance through Medicaid, you cannot use it to cover abortion care. And the Supreme Court said that was perfectly constitutional. what ended up happening when we got to 1992 and the Casey case out of Pennsylvania was that although the court upheld the basic premise that there is a federal constitutional right to abortion, it changed the standard for how laws that attempt to invade upon or intrude upon or interfere with that right will be assessed. And so before Casey, particularly anything that would have in any way inhibited a person's access to abortion in the first trimester would be routinely struck down by the courts. Now, after Casey, we have this undue burden standard and things like mandatory waiting periods up to 72 hours, forced ultrasounds prior to receiving your abortion, what some folks like to refer to as misinformed consent, where the government requires providers to tell you a bunch of not particularly factually accurate information about abortion before you can have an abortion. All of those things were considered to be perfectly acceptable as a constitutional matter under the Casey standard. And the most recent sort of issue that we've been dealing with is TRAP laws, or targeted regulation of abortion providers. So laws that require abortion providers to meet certain medically unnecessary standards that no other provider of similar care with similar risk profiles has to meet. In the Whole Woman's Health case in 2016, the Supreme Court said that one such law out of Texas was unconstitutional under that undue burden standard from Casey, because it didn't really have any actual medical benefits and it burdened a lot of people's access to choice to have an abortion. But obviously just this year, that was whether that would be upheld was questionable. In the June Medical Services case, a majority of the court did end up striking down Louisiana's TRAP law based on the Whole Woman's Health precedent, but Chief Justice Roberts, in a concurring opinion, really cast into doubt how we apply the undue burden standard, how rigorously we will ask states that are trying to regulate abortion in burdensome ways to really justify what they're doing. And it basically means that we're still in a scenario where states are rampantly passing various attempts to chip away at abortion rights. And time and time again, providers or others are having to go into court to challenge those rights. And some courts side with the right to abortion. Some courts say, those regulations are okay. And we have this patchwork of different laws and different levels of access throughout the country.
Thank you, Emily. Jennifer, I imagine Planned Parenthood of Illinois is impacted by all of that, including the federal precedent and the patchwork of state laws around us. Do you want to speak more to that?
I do, Dana. Thank you so much. And to build off of what so many of my colleague panelists have said, really Emily is helping to set the reality and the patchwork that we have. My colleague Planned Parenthoods and also independent abortion providers are in court pretty constantly trying to resist the latest restrictions that are getting put on by governments, by the governors during the pandemic, when multiple governors across the country declared that abortion was not essential care and attempted to outlaw it. So there were executive orders in multiple states across the country that were seeking to outlaw abortion because of the pandemic. And just to help put a bit of a fine point on the things that Emily mentioned, when we talk about mandatory waiting periods, you're talking about forcing a patient to go to the doctors twice. So that's a patient that needs to get off of work twice, get childcare twice, because as Aisha mentioned, most folks who get abortions are already parents. So they've got to get childcare twice. They have to make 2 trips to a medical office now during the pandemic, when most of us are trying to avoid A, going out at all, or B, going into medical offices in general. And so like the practical implications of these barriers mean that even if providers like Planned Parenthood or our independent partners are successful in court, the practical barriers for the patients are almost overwhelming. That the patient then might go in for that appointment, get a medically unnecessary ultrasound, or have a script read to them by a medical professional that's written by a conservative politician and contains blatant falsehoods. So there's just so many things that impact the patients on a day-to-day basis. The implications of these laws, it can sound kind of academic, but the reality is that, as my colleagues have said, the reality is that people with money and privilege can still manage to access care, but folks who have other barriers or other challenges have an ever diminishing access to care or ever increasing number of hoops that they have to drive through, including somebody who literally had to come from Texas in the middle of the epidemic to Illinois to get care and found out that it was a 2-day appointment. So it's just a really, the reality of what the courts are doing impacts so many lives across our country. And I just wanted to bring that point home.
Thank you, Jennifer. So you mentioned, Jennifer, some of the impacts on folks who have to come from a distance. Aisha, I understand local judges are often not, they don't have a good grasp of what reproductive justice actually looks like and what the laws actually dictate, and you do some work in that area. Would you like to tell us more about that?
Yeah, absolutely. It's sometimes shocking to people to learn that judges don't actually have to have certificates or degrees or vetted research around the issue that they're judging on, which is something that we come across all the time, where we're saying that politicians and people in politics should not be making healthcare decisions or should not be talking about science that they themselves don't understand. And also in my domestic violence work, I saw that there were judges presiding over domestic violence cases who did not ever go through a 40-hour domestic violence training program or even understand the actual definition of domestic violence, which in Illinois includes threats. It does not only include actual physical harm, right? And so a lot of advocates spend their time trying to educate these judges, but it's hard to get your foot in the door. If it's not mandated, people don't want to talk about it, right? And because judges are in their position for so long, when they learned about what was happening in the laws, it was probably a long time ago and laws have changed. And also if they themselves are from a privileged identity, will definitely not understand the context that people are coming to them, right? So imagine, like specifically for the parental notification of abortion law, imagine a young person, a minor, speaking to an old white man judge about why they can't tell their parents about having an abortion, and the judge being like, well, I would want my kid to tell me, so therefore, I don't agree, and not having any of the work that, like, the nuances in the campaign that we've talked about in regards to P&A around why we're supposed to trust people and why this is actually not a helpful barrier. If the goal is to keep people safe, P&A, parental notification of abortion, doesn't actually keep people safe, right? And having to do that work requires advocacy and requires conversation, and it's just not happening. So it's very surprising to people that you don't have to be an expert on something in order to make a decision about it that could impact somebody else's life. And that's really, really unfortunate, because also if a young person is receiving a bypass, what is the reason that you go to court? Because you did something wrong, right? So you're already placing that burden of, like, I must be doing something wrong, which is why I'm here in order to begin with, right? So there's just so much shame and stigma also that's attached with the way that courts hand out decisions. And also there's a lot of judgment of the person's character and their experience without really centering empathy or really trying to understand where that person is coming from. So it's really unfortunate that, like, first of all, that people can have varied experiences in the court system, but also that you could go to one court and have a different outcome depending upon the judge versus another court, right? And so I think that part, the subjectivity of our court system is also surprising to people, because I think people feel like it's cut and dry, it's black and white. We know what's the right decision and what's not. And it's never that way. And it hasn't been that way because also our courts have always been conservative. There was a very, very rare moment in like the 60s and 70s where we had a slightly liberal court, but they've actually been inherently conservative. And so even when Democrats have their picks for court nominations, they're a lot of times picking people of the center, and we're not picking progressives, right? When Republicans are really picking people who are on the right, really on the far right sometimes. And Democrats are continuously like picking center, like people in the center, and we need to have a larger shift in that too. Our courts have inherently been conservative. The roots of courts have been conservative, right, to begin with. And that's also part of the RJ framework, is if we don't understand the roots of where the system was created, we're not going to actually fix the system. And the roots were not to uphold human rights, unfortunately, in the same way that we've been thinking about them now, as opposed to how we thought about human rights at that time. And so if you imagine a young person having to take off virtual school in order to go to court, and do a virtual court session, right? And be on spotty internet on their tablet that they might be sharing with their sibling, and then also having to hide and do all of that, right, at home. This is not an option for a majority of people. And then folks can't necessarily leave. Even survivors of domestic violence who are now stuck at home or can't leave are also in that same situation for seeking care, for seeking abortion care, right? Reproductive oppression and coercion happens. And so being able to even get on the computer to have some of these appointments, like having the legal right to it is one thing, and then actually getting to be able to use that right is the other piece. And both of them are extremely controlled right now. And it's scary, but I also want folks to know that HB 40 exists in Illinois. Medicaid provides financial coverage of abortion care in Illinois. We also have the RHA, which protects our right to abortion care as essential in Illinois. And this is why state laws and state politics are so important when it comes to the national arena. We took so much effort to do this proactive RHA law when people were like, we'll be fine. We don't need it. We'll be fine. What are you worried about? Illinois is fine. We're progressive. We're fine. And now it's just like, I'm so glad that we have that as our foundation floor, because I could not imagine going into what's happening now with potentially having to go back to spousal consent, which was what was required in Illinois before, spousal consent for abortion, right? And so just thinking about that too, of like, this is why having proactive laws being passed at the state level is really important.
Thank you, Aisha. Jennifer, did you want to say a few words to that?
I did, and I really have to echo Aisha. We are lucky that we had supporters like everybody on this panel, and probably a lot of folks who are listening right now, who helped us pass both HB 40 and the RHA in Illinois, because we're surrounded by states that don't have that kind of access. And once we lose access in the Supreme Court, which, as Carol said, with the inevitability of this latest nomination to the court, means that the loss of Roe is also inevitable. And I definitely hear what my colleagues are saying, that Roe has never been helpful for everyone, but it was an important right for many people. And what we have now is 17 cases that are marching their way to the Supreme Court that will either eliminate Roe or just continue to chip away until it's irrelevant. And what that means, based on the laws of all of the states across the country, is more than 25 million women in our surrounding states will not have access to care. And so that's why the great work that we've done together in Illinois to pass HB 40 and the RHA were so important, because we will be a haven in the Midwest. Patients already come to us for care, and that number will increase even more. I have to agree with Aisha. We still have work to do here in Illinois. Everybody on this panel is committed to repealing the Parental Notification Act, but we're fortunate that we can help our patients both here in our state and in the Midwest even now.
And I think that one of the themes between the things that the two of you both said, was that access to resources is access to reproductive justice. So if you have the money and you live in Texas, you can get to Illinois. And the people who are least likely to have the resources necessary to access reproductive justice are the very communities that are being hit the hardest by the pandemic and the economic recession. Jennifer mentioned some of the pipeline cases that are coming through to the Supreme Court. Andy, did you want to speak to the trends in the courts these days?
You know, I want to just build on what we're talking about right here, and not to be the downer of all this, but to make it clear that overturning Roe for the antis is not the goal, it is the beginning. It is step one, because they do not want people with resources to be able to access abortion either. It was easier to take away access from people without resources. The Hyde Amendment was done because it's easiest to go after people with the least amount of power. But the real goal is to get a reinterpretation of the Constitution to create personhood rights for the fetus and for the embryos, which would mean that nobody in any state, as blue as it was, could access abortion care. So just to be really clear, because for a decade or so, those of us who've been working in this, been saying, they're going after Roe. Everyone, we're fine. We're never going to lose Roe. And it made it harder to make it clear how bad things were even under Roe. And it was the Chicken Little, the sky's falling, sure. And now that we are actually pretty much going to either lose Roe or it will be gutted, as Jennifer said. Gutted is frankly our best case scenario at this point, and it's unclear how best that is, that everyone believes it and it's too late. So now we need to start telling people, look, this is not the end game. The end game is personhood. And we have evidence about this all over the country, where you can see laws scattered throughout the books, little ones that often don't get all of the attention, where a criminal law is written in a way that instead of saying a pregnant person has perhaps special protections in a crime, that instead the fetus has its own separate rights. And when you give rights to a fetus, you must take them away from the person that the fetus is inside, right? There's no way for it to exist otherwise. And we see this happening where some of these laws that were supposedly supposed to quote unquote protect the fetus are being used to criminalize pregnant people. A woman in California who's currently been arrested and held with, I think it's $1 million of bail or something insane, because of an accusation of drug use during pregnancy, under a law that was supposed to protect the fetus in an instance of violent crime. And this person is in jail. I recommend the work of National Advocates for Pregnant Women on this. So this is already happening. People are already getting imprisoned for the outcomes of their pregnancies, for C-sections, other things. And it is important to note that that is the final goal. That is what the organization that Amy Coney Barrett signed on to an ad calling Roe barbaric, calling for Roe to be overturned, which makes it so laughable that she's sitting in front of the judiciary as we speak, claiming not to have an opinion on the subject. That is what that organization is calling for. It is for a fetal personhood, ban abortion, ban IVF, as was mentioned earlier, and take away some forms of contraception. So least we think, oh, well, we've hit rock bottom when they take away Roe. Absolutely not. They are just getting started. And that is why we need to start talking about this and building that power, so that in 10 years from now, we are not on this same panel talking about how we're going to start flying people to England and drive them to Canada to get their abortion care.
I mean, I think that even highlights further that resources are very critical to access until we have a better system in place. Does anybody else want to speak to, Jennifer, you mentioned 17 cases in the pipeline. I didn't know if you wanted to share with us any insight into the sorts of issues that are going to be decided shortly.
I think that Emily has started talking, I think it was Emily started talking about them, that it's a category, it's trap laws, it's medically unnecessary procedures before patients can get care. One of the specific trap laws, the one that we saw in June Medical, is the the requirement that medical professionals have admitting privileges at a nearby hospital. And I think that this ties to other important work that folks like the ACLU are doing about the increasing number of religious affiliated hospitals. And so if you are a patient in a place like Peoria, where the one major hospital in the whole region is Catholic affiliated, and they don't allow anybody who doesn't follow the religious care protocols to be affiliated, to even rent space from them. So there's no way that medical professionals could get affiliated with the single largest hospital in the whole central Illinois region. So that's an example, and I know that my colleagues in surrounding states are really facing that all the time. So those are the types of increasing restrictions that are headed to the court. And we really feel like in June Medical, Chief Justice Roberts didn't open the door, but issued an invitation for people to attempt other types of restrictions. Like that one didn't exactly work because it was too much like whole women's health, wink, wink, nudge, nudge, maybe try something else. And so we'll see what, one of the many opportunities comes in front of the Supreme Court soon.
And I just want to say, it seems like Emily has a few words to share with us. I just wanted to say for those of us in the audience who are not JDs, that often a Supreme Court decision will hold, will land on a not controversial holding, but will have sort of a PS embedded about how the plaintiff in the case can get the decision they're looking for. The objections to the desired outcome and how to overcome them, essentially. So it's like a roadmap of how to get to personhood, for instance. The justices can sort of embed that in a decision so that future litigants have more luck. And also, the joke in law school is that the best way to predict a judge's opinion is to know what kind of eggs they ate that morning. Because as Aisha said, as a bunch of the panelists have mentioned, it is not black and white. The laws are very much open to interpretation, especially when you're not issuing precedent-setting opinions like they are in the Supreme Court. So local judges just sort of do whatever they want. And with that said, sorry, Emily.
Yeah, I just wanted to say, that we're definitely, I totally agree with Jennifer that Chief Justice Roberts' opinion in Jude Medical really was sort of like a invitation for states to continue to pass trap laws and other attempts to burdensomely regulate abortion providers out of existence. And we're seeing that now in the lower courts, different courts are having different interpretations of June Medical already just a few months after it came out. There are also cases in the pipeline, however, that are much more frontal assaults directly on Roe, where we have states that passed basically bans on abortion throughout pregnancy or as early as 6 or 8 weeks in pregnancy when many people don't know that they're pregnant. And those cases are also working their way through the courts. So, and those are just frontal assaults on Roe, and it'd be really hard for the court to find a way to uphold one of those bans without just, putting the final nail in Roe's coffin. So, there are cases that are coming up that are, just further opportunities to chip away at Roe and make it less meaningful for more and more people. But there are also cases in the pipeline being litigated that are just basically, attempts to say you have no right to abortion in our state at any stage of pregnancy, and those cases will find their way to the court presumably sooner rather than later at this point.
And with a consolidated majority of 6 conservatives against 3 progressives on the Supreme Court, the decisions on those cases when they make it to the Supreme Court will be different than otherwise. If Merrick Garland was on the Supreme Court, for instance, or if future president, potential President Joe Biden was able to replace Ruth Bader Ginsburg. Would anybody else like to say anything about the trends in the courts? Or is it time to pivot to the significance of the current SCOTUS nomination on the future of access to reproductive justice and healthcare?
I think we can pivot. I think there's, you know, there's a lot, as Jennifer said, there are 17 cases, and, you know, Emily and Jennifer were elaborating a few. I mean, I'll add on method bans also is one that's sort of a high likelihood of making in front of the court, which means banning a type of abortion care that would essentially ban abortion after about 12 weeks by making it extremely hard to provide and taking away the most common methods for providing it. This is a backdoor ban method. And also I want to flag reason bans, because that's coming up a lot, especially right now in the Amy Coney Barrett. So this might be a good segue, where states are banning abortion because abortion, when it's the reason for the abortion is the race or sex or a fetal abnormality such as Down syndrome with the baby. These are super cynical types of bans, and they are meant to be wedges, and they are very racist in their implications and need to be called out as such. But they are very popular with the antis because they know that without more explanation, that often there's a gut reaction of, oh, that should be bad. They also, the antis really want to take on the frame of feminism. They like to argue that they're trying to help women. And so those are also a way that they are for supporting people with disabilities. They're for supporting women, because look at, they're passing these abortion bans. So they are very cynical efforts. And we've seen language from justices already, such as Justice Thomas, showing a lot of sympathy for these types of arguments, and they play into a lot of pernicious stereotypes. So I want to just flag those as well as things too. If you're watching what's happening here, you're kind of keeping an eye out for those types of cases as well.
And I just want to say, before anybody else chimes in, that if you have any questions for our panelists, now's the time to enter them in the chat bar. We would be happy to present questions to the panelists as we move forward with the panel. I did want to highlight something that Andy had said about a lot of these issues being very emotional, or framed in such a way that one issue voters will be swayed by their emotional response to the issue. Former presidential candidate Pete Buttigieg, and I will remain agnostic about him as a candidate, but he responded to a question about late-term abortions that was framed in such a way to elicit an emotional reaction, and he called it out for exactly what it was and described the very rare traumatic circumstances under which a woman who clearly is carrying a pregnancy with the intent of carrying it to term has to consider such a medically necessary circumstance. And I thought it was a great way of responding to that question. I know other countries don't have the same sort of approach to this issue that we do. I'm wondering if any of the panelists have any opinions about how to get to a place where there isn't a constant assault by folks appealing to the one issue voters, trying to eliminate access to reproductive justice and achieve personhood laws. If there is a route to embedding this right forever, for the foreseeable future, for posterity. That might be a daydreaming question that there is no answer to.
I mean, I might push back on the premise that it's about embedding the right, per my opening statement, that it's more about shifting the power dynamics and doing so in our culture as well, that the default should be abortion is about freedom and control of your own lives. I mean, I think, you know, I actually think that Pete Buttigieg quote, the better part of it was frankly the first half, where it said, you know, I'm not the one to draw the line for somebody else. We shouldn't be drawing that line for somebody else. We don't know their circumstances, whether it was a wanted pregnancy or not, whether they just had barriers in their way that so they couldn't get to care because they were young, because they didn't know they were pregnant, because they couldn't access the money, whatever the reason why they're having an abortion later in their pregnancy. I'm not the person to draw the line, and neither is the government. But so really it's about a cultural shift in our country to appreciating that. And we have the majority, and it's about talking to them, and it's about engaging, and it's about building power, as I said at the beginning, so that the majority's will is actually represented. Because if it was, we would have abortion access. So I think it's going to be a constant battle until we shift that thinking. Jennifer, go for it.
Yeah, I was going to say, I think that's what's so interesting about where we are right now, and it's, you know, so many of us have touched on it in many ways. The political will is currently, the political power is to further restrict access to abortion. And it leaves out a couple of important facts. One, that abortion is healthcare. That's the first thing. And that's simply, I mean, granted, under the current Supreme Court, healthcare in general, or access to healthcare in general, is at risk for many people, you know, and so maybe that's not the panacea that it ought to be, but abortion is simply healthcare. For the patients that need it, it is part of healthcare. And the point that we always make at Planned Parenthood is we trust the patient to make the decision for them, not a conservative politician who happens to be running the state house or the Senate. And poll after poll indicates that most people, at least 3/4 of the people in the United States, poll after poll, year after year, even when Fox News does the poll, indicates that most people in the United States support reproductive health and a full access to care. But conservative politicians have fixed the system so much in their favor that they are able to ignore the will of their constituents and the vast majority of people in our country to perpetuate their ever decreasing access to this one portion of healthcare. And I focus on access because, and this is something that I think every panelist has said multiple times, what we are really committed to doing is closing the gap between the law on the books and the actual access to care, that we need equity in access to care, not just the law exists and so we have the right. Where there's no access, the right doesn't exist.
And where it would take extraordinary resources to access the right, it also essentially doesn't exist. I feel like a lot of issues that are confronted in various areas, criminal justice reform, access to justice generally, are enmeshed in the same sorts of issues. The Electoral College versus the popular vote, for instance. We've got gerrymandering, we've got Citizens United, we've got the influx of dark money impacting election politicians' choices during an election, because if they go against dark money, then the dark money gets their somebody else, their opponent in the primary, up for election, et cetera, et cetera, et cetera. I want to remind the audience that if you have any questions for these amazing panelists, you should enter them in the chat right now. I'm really curious about how we can help actual members of our communities in accessing reproductive justice and healthcare. I utilized Planned Parenthood for an OBGYN appointment in college, so I know that's one way, right? Aisha, do you have any comments about how folks can assist members of their community in accessing justice, reproductive justice?
Absolutely. There's multiple strategies, I think, but it starts with sex education. It starts with comprehensive, medically accurate sex education that is not centering abstinence, right? But still talks about abstinence as a sexual choice that people can make. And the reason why that I say that we should not be centering abstinence is because people can choose to be abstinent and still be sexually assaulted and still require abortion care or emergency contraception. And abstinence is not the thing that protects you, right? And knowing what you have rights to, so also having sex education include your legal rights to care, right? Which is something that ICA, Illinois Caucus for Adolescent Health, does really well. It's like you can't talk about how to care for yourself if you're not talking about how to get that care as well. So starting with that, public awareness and education is incredibly important, right? So when we see things on the federal level that create panic, we maybe don't realize what resources we have accessible in our communities, right? And so while when we had a lot of the 6-week abortion bans in certain states, there was a lot of fear that like no abortions at all right now, which is not necessarily true. It's just really, really restricted. And so we don't want to create misinformation, but we still want to talk about how the narrowing of our rights is still impacting people. And really like letting people know what they can advocate for too. So, you know, as judges are not reproductive healthcare providers are also not judges and lawyers, right? So our doctors are not necessarily going to know what is best for us when we're accessing care, or even when we're working with young people. There might be some misinformation where they assume that parents have to be involved in certain decisions when they don't have to be. For example, in contraception, right? Minors have access to contraception without parental involvement. But part of this is like we need people to be informed about what healthcare looks like, what types of healthcare exists, why abortion care is part of all maternity care, actually, because people who experience any form of pregnancy loss, including miscarriage, it's managed with the same medication and procedures as it is for abortion. We just call it miscarriage, but a miscarriage used to be called spontaneous abortion, while abortion is, you know, induced abortion, right? And so thinking about how even shame and stigma changed the name for what we call it. We used to be able to say spontaneous abortion and know what that meant. And because of abortion stigma, we have to call it miscarriage because the way that the word lands on people. And then folks are advocating for themselves. Providers are advocating for their clinics. And then, you know, we have legal advocates advocating for just like the bare minimum rights to be able to then get that care. So there's a lot of different strategies. I definitely recommend, you know, Googling is our friend, but also that's a rabbit hole that people can fall into. And so my work this year actually is centering around public awareness and education, so people can know what we have the right to in Illinois. What does the Supreme Court mess mean for us in Illinois? And also, what are some things that we can engage with and to do advocacy around? So that's all connected. Advocacy requires education and moves people to do that work. But I think people are surprised when they assume that whatever they need will be covered because they have health insurance or they have a primary care doctor. And they're like, if I need something, I'll be fine. But it's only in cases of emergencies where you think like, where you realize that actually everything is not covered, right? Specifically people who are maybe seeking miscarriage management. And we were talking about Catholic institutions as well, as a growing institution for healthcare. 1 in 3 hospital beds in Illinois is in a Catholic institution. And so when you think about people who are pregnant and seeking even places to birth, if they're having to birth in a Catholic institution, they might not get postpartum care. And if they have a complication with their pregnancy, they might not get the care that they need in that too. And so really connecting the abortion care, contraceptive care as part of all sexual reproductive health care, as all part of all ways that we create families and not separating it out is incredibly important. And I think people just feel like if they're not going to get an abortion, they don't have to worry about anything. And it's not that simple, actually.
Dana, I would just, you know, building on that, you know, 100% ditto all of that, and, you know, add on something that Aisha and I have talked about a bit before, which is my favorite prop, medication abortion. This is a box of medication abortion pills. It's empty, but got it for a photo shoot. But, you know, it's 60% of abortions that happen in the first 10 weeks, which is when medication abortion is available as an option, are done with these pills. It's a series of pills and it induces a miscarriage, as Aisha was just saying. It is incredibly safe. It is safer. It has a higher safety profile than aspirin or Tylenol, things that you buy every day without any doctor's note, and yet they are tied up under lock and key. There have been some changes because of COVID to allow telemedicine to expand, but that's not the case in 17, 18 states where the state legislatures don't care about science or frankly women's health really and want them to risk COVID to get their medication abortion. These should be available via telemed. They're increasingly popular, as I said. And also there's a large effort, groups that I'm working with around normalizing self-managed care, that you should, if you can have access to quality pills, good information, backup care in the case that you need it and can get your questions answered, there's no good reason, medically speaking, why someone shouldn't be able to take these pills on the timeline that works in the way that works for them. And that would obviously, you know, we're seeing a lot of pushback around medication abortion calls for more restrictions on it because they know that. Everyone should have the option to go to a clinic. I want to make that very clear. Everyone should be able to get the care how and where they need it. But with medication abortion, they can't stop us. They can't protest at everybody's house. If you can get it via mail, deliver it in a box on your doorstep, the way you do with everything else in your life right now, it would change the access to abortion care forever.
Thank you. And Emily, when we prepared for this panel, we talked a little bit about privileging religious rights or religious objections. Did you want to speak a little on that?
Yeah, I just think, it's come up a few times, and the points that have been made are crucially important, that this is yet another really significant barrier to reproductive health care that a lot of people face, is that they are geographically in places, or they are part of a health plan that is bound up with a religious healthcare provider that doesn't provide, comprehensive reproductive health care for religious reasons, but most people don't actually know that till till they're seeking that particular type of care. And that the idea that not just the individual doctors themselves, but the institution should be able to dictate what healthcare is available to these vast swaths of patients is really part and parcel of a general privileging of religious objections that the right has been seeking to advance, both politically and through the courts, and which I fear Amy Coney Barrett would very much get behind. So, for example, there's a case pending in the Supreme Court involving foster care in Philadelphia, and Catholic Charities was told they couldn't participate in the foster care system in Philadelphia because they wouldn't agree not to discriminate against LGBTQ people, and they've sued for that reason. This is a generally applicable rule that all people who want to engage with the city of Philadelphia in this way and provide these particular human services are supposed to agree not to discriminate. And they want to basically be treated specially because they're Catholic Charities, and they think they should be allowed to discriminate because that's what their religion tells them to do. That case is pending before the Supreme Court. And if the Supreme Court rules with Catholic Charities, it'll just open a whole Pandora's box of people, and not just individual people, but large institutions, Catholic hospital systems, et cetera, basically being able to write their own rules when it comes to who they will or will not serve. And that's a very, like the personhood issue that Andy brought up, that is a very scary potential future, and one that I think is unfortunately quite likely in light of where the Supreme Court has gone.
We've had a lot of remarks about the doomsday consequences possible if Amy Coney Barrett gets nominated or appointed to the Supreme Court. In the absence of any questions in the chat, again, a reminder to participants that they can enter their questions in the chat. If each of you would like to take a minute or two to make some closing remarks, whether optimistic or pessimistic is up to you, that would be great. Jennifer?
I'll go with, I know everybody's going to be shocked by this. I'm going to go with optimistic. First of all, I want to thank you, Dana and Carol, for having us today. This has been an amazing conversation. Have you guys seen me? I'm taking notes furiously because my co-panelists are so brilliant. It really is a privilege to be able to work with you all. And I want to remind everybody that today is election day. And so is tomorrow, and so is the next day. We are in the middle of an election right now, and the good thing is that we have an opportunity to impact many of the issues that we've been talking about today by exercising our vote. So that's the last thing I'll leave you with, is go out and vote.
I'll keep the positive train going and say that while there is a lot of work to do, we've always known that, there always has been. And I heard a quote recently that it was fear plus hope equals action. And then a colleague said, actually, I think it's different. I think for progressives, it's anger plus hope equals action. And I liked that even better, because the other side pedals in fear. We are justly angry, but we have that hope. There is a vision. We need to keep talking about it. We need to hold not just the other side accountable. We need to hold our own champions accountable, that there has to be real progress on expanding access to all sorts of reproductive health care, including abortion. Codifying Roe should be the first step of many to making access real. And so I'm going to take my anger and my hope and turn it into action. And I hope we all can do the same.
Well said.
Just in that vein, you know, we've talked a lot about the fact that we are fortunate here in Illinois that we have made some really important steps in the last few years to protect people's access to abortion, to expand the access to abortion for those, for example, who get their insurance through Medicaid. But there are still folks in our state who don't have equal access, including the young people who are subject to the Parental Notice of Abortion Act. So I think sometimes things are so dire everywhere else that we can forget that there are still people here in Illinois who aren't getting what they need. And I want to encourage us to, you know, tell your legislators that you support repeal of parental notice of abortion, that you support many of the great things that Everthrive Illinois is working on to expand access to contraception in various ways. There's still more we can be doing, even, you know, in our local and state communities, as well as obviously trying to be allies to the folks in surrounding states who are admittedly in a worse position than we are.
Well, I'm going to be positive too, and part of that is we had a proactive abortion bill pass already, right? RHA passed in Illinois, and that the need for proactive approaches instead of just defensive, I think was, you know, really made apparent in that and moving forward. And so we hoped to dream bigger than just wanting to codify Roe, like we've talked about, right? We want it to be bigger than that. We wanted to go further than that, including, you know, the work that Everthrive's done about like 12-month postpartum coverage in Medicaid, and making sure that people get a full year's worth of postpartum coverage instead of the 6 weeks, which a lot of times people miss that appointment, right? And so that our work here is also around maternal and child health and supporting the positive outcomes, and that you can't do it separately. And you can't really leave out young people in sex ed either, right? And so all of it is together. I think that people know the benefit now of these proactive policies and why we should care and pay attention. And currently, you know, that people are able to advocate more. There's more ways that we can do advocacy from home now, right? With a lot of digital advocacy campaigns, including Advocates for Youth is doing a youth call-in day tomorrow, specifically around Amy Coney Barrett, to say that she should not represent our courts, right? And the hashtag that they're using is Our Court. They're doing a call-in tomorrow between 1 and 4 p.m. Eastern time. Specifically around this. There are other organizations. I just got that email this morning, which is why I'm plugging it. But like, there are other organizations who are doing campaigns around calling in to delay the vote, right? Like, no voting right now. This is not, no COVID check, no voting. Like, we're not doing this, right? Like, this is just not the priority. And for folks to get involved in any way that they can, because we're also talking about people who maybe don't have the right to vote right now, and how can they be involved? There are a lot of people who don't have that right to vote, and including people who have been protesting recently, who've been charged with felonies, people who've been protesting the racial injustice, who have been charged with felonies, which is just for protesting, for nonviolent protesting. This is an active strategy to suppress the voices of people who dissent, which I know is RBG's biggest legacy is dissent, right? And we need to continue being that voice and dissenting in these places, and really calling on the people who have the privileges to vote and call their senator to do that, to step up. White folks, people who are not marginalized, to really take that charge as well, as we also do a culture shift around how we talk about these rights and how they impact our lives and our families.
Thank you all so much for being a part of this panel. I just wanted to thank you before I turn it back over to Carol. It was a pleasure.
Well, and I'm going to do some thank yous too. This has been a really informative, wonderful panel. So I want to thank all of our panelists for your wisdom and your insights and what you've shared with us today. I want to thank Emily from the ACLU and Andy from AF Advocacy, Jennifer from Planned Parenthood of Illinois, Aisha from Everthrive Illinois, Dana for being our wonderful moderator and part of Courts Matter Illinois. And behind that Courts Matter Illinois sign is Mike, our Courts Matter outreach coordinator, who made everything run smoothly today. We couldn't have done it without him. I also want to again thank our sponsoring organizations. I'm not going to run through all the names, but we're very grateful for your help with this whole series. Third, I want to thank all of you out there behind your blank screens who have joined us today for your participation. I want to remind you that this is the last in our series of 6 webinars on Courts Matter in the 2020 election, but that all of them are available to view on our YouTube channel. So please tune in. We hope you'll join our Courts Matter Illinois family and advocate for a fair and just federal judiciary. Check out our Facebook page. That's where you can find best place to find us, or email us at courtsmatterillinois@gmail.com. And fourth, Aisha already told you about a call-in tomorrow, but today is actually also a call-in day. So I'm going to give you a phone number, 202-224-3121. That's the number for the Capitol switchboard. Today is a call-in day to the Senate. So when you leave this webinar, call, ask for your senator's numbers. I know there may be some people who are not from Illinois here, but call and tell them that you oppose the nomination of Amy Coney Barrett to the Supreme Court. No one should fill the vacancy of Ruth Bader Ginsburg until the next president is installed. And no hearings should be held during this pandemic right now. If this nomination is pushed through, you are asking your senators to vote no on this nomination. So please remember that courts matter. And please vote if you've not already done so. So thank you for joining us and have a wonderful afternoon. We really appreciate that you're out there. Take care, everyone.
Have a great
Bye-bye.
day. Don't forget to vote.